All right, welcome everybody. Today is the last of our planned series on legal topics with Kris Goss. This is an important one. Not that others haven't been important too, but it definitely builds towards the ideas that we really need to abide by, the laws that we need to abide by when we are conducting the business of the public. And so an executive session is one of those special situations where you want to be particularly cognizant of the laws that govern a public meeting. As I said, this is the last of our planned series, and you can find the recordings for all of the past items in this series in our YouTube channel. And I've also recently set these up as individual courses in our MSL Learn online course platform for your coworkers and others to be able to watch, discuss, and to get credit for the learning opportunity. As with any of these topics, we want to make sure that you consult with your own attorney if you have legal questions. This is informational and it does not constitute legal advice. So, with that, Kris, I'm going to turn it over to you.
Thank you. And as you noted, this is the final session of the planned series, and it's strange to think it's gone that fast. We just started this process, and it's been a great journey. And I still have summer noted here on the front slide because I think we'll slip it in just before the snow flies, but we'll still consider this final day of September to be the summer of 2025, given that it was 80 degrees yesterday. But this final session is, as Coley said, closed sessions, executive sessions during library board meetings. And it's one that's very important for every library board and every library director, library administrative staff to remember, because it is so important for the public to trust in the operations of the library. We are, as librarians, information professionals that make sure people have access to information consistent with their rights under both the state and U.S. Constitution. And part of that is the transparency and accountability of how that information is gathered, how it is distributed, and ensuring that the public, the taxpayers, policymakers all understand how those operations occur. And that happens in Montana through compliance with public records laws, open meeting laws, and ensuring that Montanans' right to access information, government information, is always honored, especially by the governments closest to the people, which are local governments, including library boards. So, as always, we're attempting to develop a foundational guidance, reassurance, and making sure that the laws of Montana are honored in the library's procedures and policies and operations. And we talk about the issues that may be emerging, issues that may have been around for a while, but always toward the goal of striving towards full governmental transparency, full and complete governmental transparency, so that public resources are directed in appropriate ways to serve the community, serve families, and strengthen our economy and strengthen our cities and counties. So we start with the Constitution, as always. What does the Montana Constitution say? It provides two distinct rights, and with the issue of closed sessions, those rights are going to interact. And it's that interaction where a library board has to be prepared to honor the law. So you see the right to know. No person is deprived of the right to examine documents and observe the deliberation of public bodies and state government and its subdivisions, which would include counties, municipalities, and by extension, the library board, except in cases in which the demand of individual privacy clearly exceeds the merits of public disclosure. So that individual privacy right is outlined in in the next section of the Declaration of Rights within our Constitution. Individual right of privacy is essential to the well-being of a free society and shall not be infringed without the showing of a compelling state interest. So you have that expectation for a local government body to make sure it honors the rights of the public to examine documents, observe the deliberations of public bodies, but also the rights of individuals to not have their personal privacy rights infringed upon by the government. And so, if there is a situation that interacts with the library board, but also relates to an individual right of privacy, then that is going to require some careful analysis to determine whether there is a need for a closed session of a public meeting. And you can see that the caution that I'm urging here, because the default expectation is that all public meetings, all governmental meetings, all meetings of a local government board, such as a library board, are open to the public. That's the default. And 2-3201 within the open meeting law statute specifically states that the legislature declares that public boards exist to aid in the conduct of the people's business. And it is the intent of this part that the actions and deliberations of public agencies be conducted openly. The people of the state do not wish to abdicate their sovereignty to the agencies which serve them. Toward these ends, the provisions of the open meeting law shall be liberally construed. That's a pretty profound statement, extending the rights of the public as outlined in Article 2, Section 9, that the rights of Montanans to examine documents and observe the deliberations of public bodies are going to be paramount, and that the default operation for any local government board is that it is going to be held in open session in full view of the public. It's only in very limited situations when there is a closed session that occurs. And so this liberal construction, as the legislature has defined it in this statute, extends to all aspects of the open meeting law. And so the next section to take into account that meetings of public agencies are open to the public. All meetings of public and governmental bodies, bureaus, agencies of the state of any political subdivision, which by extension would include the library board, are open to the public, must be open to the public. And that extends not just to the full board, but to any committee as outlined in subsection 6, committee or subcommittee appointed by a public body for the purpose of conducting business within the jurisdiction of the agency is subject to the requirements of this section. So committees, full boards, all of those items are in default mode open to the public. And that is not just a constitutional right of each Montanan, it's an expectation that the legislature has set forth for political subdivisions and their boards to operate in a transparent and accountable way in accordance with the law. So the open meeting laws, as I've said a couple of times, the default is that local government boards conduct business in a transparent manner. And then when the members of the board are present, either physically or by means of electronic equipment, to hear, discuss, act upon a matter, then over which that board has supervision and control, then that expectation exists for compliance with the constitutional rights of Montanans, the laws established by the legislature, and the expectation of the legislature to have those laws liberally construed. If you take it a step further, the judiciary in Montana, the Montana Supreme Court, has also confirmed compliance with the open meeting law to be a foundational right of each Montanan. And Montanans have a right to know what their government is doing, how the funds are being spent, how the decisions are being made. And so we just have a consistent series of cases ruling that local government boards have to comply with the open meeting law and interpret it and honor it in as broad a manner as possible, except in those few situations where a closed session may be permitted. The question that always comes up then is, well, the open meeting law only applies when there's a quorum of the board or a quorum of the committee that's present. And that's not exactly the case. A quorum is a defining characteristic of a meeting when binding decisions can be made, meaning that the quorum exists and is present at the meeting, and the majority of that board or committee is present, and that means that a decision made at that meeting can be binding upon the local government body. It does not mean that if a quorum is not present, the open meeting law doesn't apply, because there still could be situations where one member of a board is talking to another member of the board. A quorum does not exist, but there still is a discussion that could result in the deprivation of the right to know that each Montanan holds. And so that's why you can see court decisions handed down around the state by the Supreme Court where quorums of bodies were not present, but there was still a violation of the open meeting law. And so the quorum can define a meeting, but that meeting that doesn't include a quorum could still be considered a violation of the law. If there's a discussion or attempted action, that deprives the public of its right to know. And so it's important to understand that distinction and keep it in mind when someone says, oh, we can just talk on the phone, we can catch up at the cafe and we can talk it through. You start talking it through and cross over into a line of predetermining the outcome of an issue, or start counting votes, or getting into the wording of motions and who's going to second the motion and what's going to happen after the motion passes, you can start to see a trend towards a violation of the open meeting law, even if a quorum is not present. So that distinction is important, and it's one to keep in mind, that we're always going to operate in accordance with the law, always going to make sure that the public knows how their money is being spent, how their government is operating. And as information professionals, as librarians and library board members, we're going to be the models for how our government should operate, consistent with the open meeting laws and the rights of Montanans to know how their government is working. So the open meeting law starts, and I start a little bit before we get to a closed session by defining what an open session is, so we can know the difference. And when dealing with a public notice for an open meeting, that's when the open meeting law process starts, is that when the public knows there's going to be a meeting. The board or its committee has set a time for a meeting. That meeting is going to occur. The public has a right to know about that meeting and a right to observe the deliberations that are going to occur during that meeting. And so in order for the public to know when it's going to occur, so that they can interact with their rights and interact with the board and observe those deliberations, then they have to know when the meeting is going to be held, where it's going to be held, what's going to be discussed. So making sure that that regular board meeting, a special board meeting, any committee meetings are going to be publicly noticed, consistent with the law and with any practices established by the library and documented by the policies. So the notice should outline where the meeting is going to be held, when it's going to be held, what's going to be discussed, how people can participate. And how people can participate may differ from community to community, especially when there is the possibility of observing meetings, public meetings, through remote operations or remote functions platforms. And so that opportunity to participate or observe in an electronic fashion should be noted on the public notice, if that is a possibility. So that posting is an aspect of state law, and how the meeting is posted is now documented in state law. You have an obligation as a local government entity to post meetings in a specific manner. And that can be through the newspaper, if there's an opportunity for electronic notices to be posted with the newspaper. And how that posting will occur depends on the newspaper's functionality, website, and rates of charge. If it's free, then this could be satisfied there. If there is not an opportunity to do that, then there's a link posted to the library's website or the social media site of the library to make sure that the public knows where to go. And you can also and should post physical postings right out the library door or the branch doors, or the public areas where postings are traditionally found to help the public know where that notice is going to be posted in a consistent manner. And so having all of those obligations met and having them documented in a library procedure, handbook, or policy even can help ensure consistency and people know where to find the notice for the library board meetings. So you have that public meeting obligation met. The community members, the people who are interested in watching the meeting, know where to go, where to find the meeting, what's going to be discussed, and they have access to those board meeting packets and supplemental information. So that's the default rule. That's the default operation. Everything's done in an open session, consistent with the public's right to know under Article 2, Section 9. But there may be a situation where there is a matter on that agenda that relates to an individual right of privacy as protected by Article 2, Section 10. In those situations, the next part of 2-3203 is going to play a role, in that's subsection 3 and 4, where there is an opportunity for the presiding officer to close a meeting when the discussion relates to a matter of individual privacy. So you see those similar terms from the Constitution to the statute, and this decision rests with the presiding officer of the board. Quote, if the presiding officer determines that the demands of individual privacy clearly exceed the merits of public disclosure, that's when you have that trigger for a closed session, meaning you are creating an exception to the open meeting law. The default rule within the open meeting law is transparency, full observation by the public. If there's an exception to that, it's for an identified reason because the demands of the individual privacy rights of that person who's subject to that agenda item clearly exceed the merits of public disclosure, meaning that individual's privacy rights supersede the public's right to know. And that's a decision that's only within the role of the presiding officer. And you can see it's only if the presiding officer determines the demands of individual privacy exceed the merits of public disclosure. So that's a heavy role for the presiding officer, but it's one that they would not undertake alone. They would be in consultation with the library administration, the director, or they would be in consultation with the library's council. A closed session, because you're weighing one individual's right of privacy versus the entire community's right to know, that's not a decision that should be taken lightly. That's a decision that should be taken with careful deliberation, careful scrutiny of all of the different facts and scenarios to ensure that these two constitutional rights are weighed carefully and that the appropriate decision is made to not just protect the individual's right of privacy or honor the public's right to know, but to protect the library and their reputation for being a location of trust and being a location where the operations are done in an open and transparent way. That's important. And if you follow those rules, then if there is litigation, then you're able to defend yourself, as we talked about throughout this process. You're not going to prevent people from bringing a suit, but you operate in accordance with the law to defend yourself against it. And the lawsuit should not be the primary determining factor in any of these situations. Honoring the public's rights, honoring the individual's rights will help make sure that those threats of lawsuits are mitigated to protect the library's interests. So you see that next sentence, the individual right of privacy may be waived by the individual about whom the discussion pertains, and in that event, the meeting must be open. We'll talk about that in a few seconds. You also have the ability for a closed session with respect to litigation when an open meeting would have a detrimental effect on the litigating position of the public agency, except in cases when both parties of the litigation are public bodies. And so that's the statute that we work from to balance Article 2, Section 9 and Article 2, Section 10 on how the rights of the public interact with an individual's right of privacy. So how does that all work? You see, there's two opportunities for a closed session: when the individual rights of privacy exceed the public's know, and it is to discuss litigation strategy. So the first step in that process is identifying when that need for a closed session might emerge. If there is a closed session and there is a possibility of a closed session, then it needs to be on the agenda so that the public is sufficiently noticed about that possibility. And it's phrasing it in a way that the public knows that there is a possibility of a closed session. So it would be agenda item, personnel matter, consideration of recommendation for termination or potential or personnel matter, library director's evaluation, possible closed session in accordance with 2-3203 subsection 3. So you have an agenda item that alerts the public that there is a possibility for a closed session. It says possible closed session, and it cites the law on the agenda. This is why we might have a closed session, because there is an individual privacy right that might exceed the merits of public disclosure. Then at the time that that agenda comes up, the board chair, the presiding officer, will make a determination that our next agenda item includes matter of public or matter of individual privacy. I have determined that the individual right of privacy clearly exceeds the public's right to know. Taking it right from the statute, using the key terms from the Constitution, so that the finding is documented in the minutes. Then there is a closed session. At that closed session, you handle the individual's privacy rights by allowing them to invoke or waive their rights. Because if you remember back here, we have the individual privacy may be waived by the individual about whom the discussion pertains in an event the meeting must be open. So you go into closed session consistent with the determination of the presiding officer. The first step in the closed session, asking the individual, do you want to continue in closed session to protect your privacy rights, or would you like to waive your privacy rights? 9 times out of 10, they'll invoke their rights. The matter will continue in closed session. There may be some situations where an individual does waive their privacy rights and the matter could return to open session. And that's why we use the word possible on the agenda item, to help ensure transparency with the public and also to not predetermine the outcome of the issue. There's no way to know how that individual will invoke or waive their privacy rights because you have not yet held the closed session. And so it's important to keep these sequence of events in order so that you avoid violating someone's privacy rights, avoid predetermining the outcome of the issue, and then by extension, violating the public's right to know by not following those specific procedures as detailed within the reading of the statute. And so there has to be that preparation before a closed session occurs. There has to be a discussion and an outline of the steps so that the presiding officer is able to follow the process and honor everyone's rights. So it's not that a closed session should never happen. It's that it has to happen in accordance with the law. And so the next item to keep in mind, and you're probably thinking about this, is there's no space for a closed session to occur without that preparation. If something comes up during a board meeting and it might relate to an individual's privacy rights, that does not mean that you go into closed session right then and there. It's not on the agenda. The individual may not be present, and you're not really prepared for that discussion. The best course of action in that situation would be to table that issue for a future meeting and move to the next agenda item so that you're able to preserve the individual's privacy rights by not having a discussion about an issue that might relate to privacy rights in open session, but also not go into closed session without sufficiently notifying the individual with whom you're going to protect the privacy rights, but also that you have not notified the public there might be a closed session. It's best to take a step back, reassess, get help, then have a meeting where you're able to handle the matter in accordance with everyone's rights. That's the advised process. And yes, there is a requirement for a closed session to include the person about whom you're talking, whose privacy rights are going to be involved. They have a right to be present for the duration of that closed session. And that means that there is a notification of that individual in advance so that they can be present, decide whether to invoke or waive their rights, and then participate fully in the closed session discussion about them and their rights. That's an important set of information to keep in mind to, again, honor the rights of the public, recognize the rights of the individual, and weigh all of those and make an informed decision. There may be situations where there is a right of privacy that does not clearly exceed the public's right to know, where the public's right to know counterweighs that individual's privacy rights. Very limited situations, possibly involving the misappropriation of public funds. Yes, an individual public employee may have a right of privacy as to their performance, but if that performance includes gross misconduct or financial malfeasance involving the public's resources, the public has a right to know about that. And so that's another situation illustrating the need for library boards and directors to be fully prepared when a closed session is necessary, so that there is not a misstep that could result in a violation of rights or potential litigation. And speaking of litigation, the law, as you saw, also talks about the opportunity for a closed session to discuss litigation strategy. This is a unique situation where there is not a right of privacy that's going to be invoked to close a meeting. Instead, it is a preservation of the attorney-client privilege. Public agencies, public boards have a right to counsel and hire counsel. And if there is a situation where that public board or agency is involved in litigation, then their conversations with their attorney should remain privileged and can result in a closed session consistent with that statute. It's important for that to be in full consultation with the attorney. It would not be a situation where there's a closed session without an attorney present in person or on the phone to discuss the litigation strategy. This preserves the purpose of the statute to honor and protect the attorney-client privilege, but also helps allow for free and open dialogue between the board and its lawyer. There is an exception to this exception, as you saw. It's not available when the litigation is against another public agency. And so it's careful to not jump the gun, so to speak, on litigation strategy closed sessions. If there's someone threatening you with a lawsuit, does that mean you're able to go into closed session? Is that pending litigation? Is it actual litigation? Is there something filed? Is it not filed? That's where your attorney would be able to weigh the ability of the board to have a closed session for purposes of litigation strategy. I think urge caution in that area. It's not a constitutionally protected exception to the open meeting law because it's not mentioned in the Constitution. It's one that's a creation of statute, and it's one that could be adjusted. There was a previous situation where the law allowed for discussions between public boards and labor unions to be in closed session, and that was removed. It was removed as a result of a finding by the court, a decision by the legislature, and because it was not embedded within the Constitution, the public had a right to know about those discussions, and it was a ruling that resulted in a change in the law. You could see a similar situation here. I think if it were to be abused or if it was somehow misused, you already see an exception to that exception. If they're both involved public agencies, there's a possibility that could be adjusted in some way. So just a word of caution on utilizing litigation strategy consistent with the intent of the law and helping make sure that those discussions with counsel are occurring consistent with the authorization from the legislature. So that's when closed sessions can occur. There's a lot to unpack there. It's not just as simple as saying we're going into closed session. It requires a careful analysis on the part of the board chair in consultation with the director and the attorney to make sure that there's no notice to the public that the possibility of a closed session exists, that the person who's going to be discussed is notified, has the right to attend and make the decision as to whether to invoke or waive their rights. If they invoke their rights, then the ability to participate fully in that closed session. During that closed session, there is an expectation that minutes be taken. This is a fairly new concept within the last 4 years, where 2-3212 states anytime a presiding officer closes a meeting, presiding officer shall ensure minutes are kept of that portion of the meeting. The minutes from the closed portion of the meeting may not be made available for inspection except pursuant to court order. So how you're going to take closed session meeting minutes is something that has to be carefully considered, because if you think about the concept of minutes would be approved by those who attended that particular meeting. However, you're not going to include closed session minutes in a public board packet, because then the public accessing that packet for the next month's meeting would be able to view all of the discussion that occurred in the closed session. And as a result, the individual right of privacy would be, in essence, waived or even violated. So there has to be careful consideration of how to keep these closed session minutes and keep them preserved so that privacy is honored and that they're not otherwise available for inspection without a court order. One approach is to have a member of the library staff or library board take minutes in real time at the closed session, and then that summary of that closed session is read aloud for everyone to hear who was present at that closed session, and then there's an agreement that reflects the summary of the closed session, and then that document is signed and sealed and preserved from public disclosure, consistent with the authorization in the statute. That's an approach that helps avoid the logical extension of the situation, which is you have a closed session the next meeting to approve the minutes of the closed session you had the previous meeting. And then next month you have a closed session to approve the minutes of the closed session you had the previous month. And then you could just have a closed session every month, just approving minutes. That obviously is a logistical comedy, but you can avoid it by having that as a self-contained decision-making process for closed sessions. And when that occurs, then you're able to stand at ease for a few minutes while someone completes the minutes. They're either printed and distributed or read aloud, and everyone says, yeah, that's a fair summary. And then as a result, they're kept and sealed in a secure location to avoid the potential disclosure and violation of someone's privacy rights. So when you leave the closed session, people who were in the closed session can talk about how they voted on the issue if that issue came up, but they're not discussing what the contents of that closed session were. They're not going to violate the individual's right of privacy when they leave the closed session. The issues that were discussed, the privacy rights that were honored by virtue of that closed session, stay with the board members and others who are present long after their time on the board. It's for the rest of their life. You're not going to disclose information that you interacted with during a closed session as a library official. It helps make sure that the purpose of the closed session is maintained and that the privacy rights of individuals are honored. And so helping make sure everyone understands that is important. But that same concept then applies when the closed session ends. When a closed session ends and a discussion is required, that decision has to occur in open session because the minutes of the meeting have to document the decisions that are made. And so if there is an evaluation of the director, so to speak, and then a decision becomes required about extending the director's contract, then that decision about extending the contract would be an open session. That's a public document about public money about a public employee, that requires the public to be able to observe that discussion. So the evaluation portion, which may be of a related to performance issues of a public employee, which could be the basis for a closed session, that ends, and you move back into open session for a discussion about public documents, expenditures of public funds, and the execution of a public contract. That means that any discussion about a potential decision is in open session without violating the privacy rights that you just protected in the closed session. And so the discussion in open session is about the public aspect of the issue. The discussion of the performance and everything would remain in closed session. It can be a fine line to walk, but it's an important one to honor, to make sure the public knows how their money is being spent and what documents are being approved, while the private privacy of the individual is honored. If you take it a different way, an individual patron who was before the board or has appealed a decision to the board about the patron conduct finding that has resulted in their suspension from the premises, and they say this is unfounded or this is improper, and I want to discuss the circumstances associated with it. There might be a situation there that has a relationship to an individual right of privacy. The board chair, after consultation with the attorney, may say, no, this is a matter of public safety, and as a result, this is a matter that's held in open session. If there's some aspect of it related to perhaps a disability or a diagnosis, and that's something that the patron wants to discuss with the board, a medical issue could lead to a determination that there is a privacy right that would have to be honored. And so if you had a closed session on that issue to hear about the medical matter that caused the potentially violating conduct, then that closed session would occur on that topic. But when it's time to make a decision about the appeal or about the determination whether to uphold the director's determination to suspend this individual from the premises, that has to be an open session. That discussion would occur in open session. The motion would be an open session. The minutes would reflect the motion, and all of that would all happen without discussing or disclosing the medical issue. So you can again see how that line would have to be preserved to honor the public's right to know while protecting any individual privacy rights. To add to the situation, the public has a right to comment on pending action before the board. We're not discussing public comment in full here today, but it is something we could discuss later if it comes up. Public comment is required whenever there's a pending action before the board. And so the public could stand up and say, I support the motion to take this action. I oppose the motion. Don't have much else they can say without violating the individual's privacy rights. And so that's why there has to be careful consideration as to whether there is a need for an opportunity to take public comment, potentially in closed session as permitted by law. Open session public comment would protect that individual's privacy rights by expressing support or opposition for the motion as it is worded. So that's when you get back into open session, the obligations to honor privacy rights remain, and they would continue while balancing the right of the public to know exactly how the library is being operated as specified in the meeting minutes or as reflected in the meeting minutes and the wording of motions to take binding action. There's a lot.
Hey, Kris.
Yep, go ahead.
Thank you. This is so much information. This is Corey from the State Library. I've been keeping my eye on the chat. And there is a question said differently. The question is, how can library boards be held accountable to be following these procedures and just the operation?
It's a great question, and the enforcement action within the open meeting law is specified that if a citizen is aware of a violation of the open meeting law And that citizen brings an action in state district court within 30 days of knowing of the violation or the alleged violation, then the district court could make a determination after review of the evidence that the library board violated the open meeting law, and it would issue an order requiring the library board to retake the action that was completed in violation of the open meeting law. So, for example, in discussion of closed session, the board has a closed session set to discuss the library director's performance. And then during that closed session, they move into a whole variety of discussion about other aspects of library operations without public observation, without honoring the public's rights to know and observe. So then you have a closed session occurring, discussing matters that are not related to a right of privacy, resulting in decision-making or implied decision-making. And then the public finds out about that. They can bring an action against the library, asserting that their rights to know have been violated. That's when a court would say, no, you have violated the open meeting law. You're required to reconvene an open session and take all of that action again in full compliance with the open meeting law. That all might seem very simple, but there's an added component. There's two added components. One is that the library would generally be required to pay the attorney's fees of the individual who brought that suit. And that's where the financial punishment comes in. These are spending public funds that would go to books and materials and staff on a lawyer for someone who brought a suit against you. And so that can be costly. The other punishment is the loss of trust in the community. And you have a finding by a court that your library violated the open meeting law. And as a result, people start to talk, people start to question, and there's a loss of trust in the work that you're doing. And that's something it's very difficult to gain back. It can take a generation to gain that back. And so those are very real enforcement mechanisms that you need to be mindful of. On the flip side, if you have someone who believes that their right of privacy has been violated because there was a board discussion about an individual's privacy rights, and it did not honor the privacy rights by convening a closed session, they would be able to bring an action against the library asserting that violation of privacy rights. And as a result, it could be that finding, it could be damages to their reputation, damages related to their emotional well-being. It could result in payments to that individual for those violations, in addition to adjustments to library operations and practices. In many cases, there would be an order requiring adjustments to the governance documents of that library, and then training required for full compliance. And that's our next set of slides is how do you develop these documents to ensure ongoing compliance? You have to make sure you have those policies or procedures, library trustee manuals, staff handbooks to make sure everyone understands the importance of operational transparency consistent with the law and the rights of Montanans. And it's not just a local issue, as I have wrote there. Each library's actions can have a wide impact throughout the United States. If it's a belief of people in Montana that libraries are not honoring the open meeting, then that can play a role in legislative action. It can play a role in other communities as to how other libraries are being viewed. And so it's best to take these matters with the seriousness that are required so that you have citizens that are informed about your work. They become involved in your work and they support your work and they both trust you and they know that you take transparency and accountability seriously. You're able to prepare for emergencies with stakeholder-focused crisis management plans. You're able to highlight the routine successes of the library through open meeting discussion and using that platform to engage with policymakers, engage citizens, as well as members of the media. And then if there is difficulty in a budget situation or difficulty in staffing, then you're able to rely on that trust to generate support for adjustments in budget or adjustments in resource management. And you also demonstrate your consistency, your reliability, and your stability through the operations that come with having these discussions always out in the open and in full compliance with everyone's rights, honoring the rights of people to know how their library is working and how that money is being spent and how the library is benefiting the community. So some brief library open meeting law policy provisions, general statement that yes, we are going to conduct our meetings in accordance with the law. We are going to provide notice of the meetings in accordance with the law and law bylaws. Our general meetings are held at this place and time at this day of the month, or may as determined by the board. Your notice of meetings could also include the location where the physical meeting notices are posted. And then you have that all laid out, and then you have the same process that applies to committees. We have committees, they're important. The division of labor is vital to our operations, but those meetings are also open to the public, and people can come watch those if they want to see some of the real nitty-gritty discussions of our library's work. You're able to come watch those committee meetings as well and see truly how seriously we take not only our operations, but our compliance with the right to know that every Montanan holds. And then a provision about how closed sessions operate, I think, is important and include in any of the library's policy manuals so that people understand that this is not something that just happens. This is a truly a special situation. It's very unique. It's not regularly occurring. It happens because there are circumstances that require it. It happens because we have competing constitutional rights that the presiding officer is carefully scrutinizing to make an informed decision about the best way to resolve that conflict. And so having that laid out in a policy and having it set forth in a way that the public can understand is an additional step towards bringing about trust in operations so that there isn't any confusion or any opportunity for people to claim that the library is not working in the way that it should. So those are some of the provisions that I'd encourage you to highlight, and we can make available to you to put together that that type of governance document. And having that outlined in your bylaws, having it outlined in your interlocal agreement is a good way to help make sure that all of the foundational documents are in compliance with section 2-3, 203 and the applicable provisions of the state constitution. So are there other questions?
Yeah, it's Corey again. Hello.
Hi.
There's another question that was posed to the state library in the chat. If the director has spoken with an attorney or the attorney, excuse me, and needs to pass information to the board from the attorney, is that allowed, or does the attorney really have to be at the meeting?
Sure. There's a couple of ways for that to occur, and each lawyer may operate a little differently. I think there's two forms. One would be written memoranda from the attorney to the board and the director detailing the issues, and that would be attorney-client privileged as well. And so we're not talking about public records right now, but that's embedded within the provision in Article 2, Section 9 that people have right to public records, and there's a whole section of statutes governing public records. But attorney-client privileged items, those that are labeled as such, would be preserved. And so the lawyer, rather than having a meeting, could provide written documentation about their findings into the research or their advice on the topic or the litigation, providing that status report that the public or that the board could review without the need for or the concern for that to be disclosed to the public and jeopardizing their litigation position. In terms of passing the information from the director to the board in a litigation strategy session would not be the advised best practice. It would not be a sound practice in that you're having that discussion about the litigation kind of secondhand, and the lawyer isn't there to answer questions. The lawyer isn't there to provide additional context or details. And then, speaking frankly, the lawyer isn't there to keep the discussion on track. And having that discussion occur without that guidance could result in a runaway closed session, like I described, where you had a closed session that might be legitimate for one reason, then it spirals into other topics and other areas that are not subject to that possibility. And it results in a potential finding against the library for abusing that closed session. So again, different lawyers will have different opinions. My thought is typically to have the lawyer present in person for a litigation strategy session, or to have the lawyer provide written memorandum to the board, and if there's a need for follow-up, having that full session, or having a future meeting with that full session, or to have discussions with the lawyer on those questions. That helps preserve not only the attorney-client privilege, but hopefully eliminates the risk of a closed session that goes beyond the scope of what's permitted. Are there other questions?
Kris, there was one just for clarification.
Last year.
What is adequate public meeting notice? Many of our libraries follow the practice of a minimum of 7 days for notice, but our understanding through work with the local government center, and this is also in the materials that we provide, that 48 hours is the minimum amount. Can you confirm that?
Yeah, that is a good rule of thumb. In my previous work with school districts, there's a statute that says 48 hours is the minimum amount of time for notice to the trustees, and by extension, the public. There's a Montana Supreme Court decision that would apply beyond school districts, that could be used as guidance for all local government boards that says the same thing. And so that is a good rule of thumb for the minimum amount. You don't want to get, I think, up against that unless there's a true emergency situation that requires some type of action of the board with limited disclosure. And that's why I think having that outlined in a procedure or in the handbook, that the meetings will be posted a minimum of 10 days in advance, or the trustees will receive the board packet a minimum of 10 days and 7 days in advance. Then you have that standard that's ready for people to rely upon. You don't want to get yourself in a situation, though, where you make it too cumbersome, and that someone then says you violated your own rules, and I didn't get this. I got this at 11:30, and the meeting started at noon, and so it was, it was actually 6 days and 23 hours and a half an hour. Then give yourself a little bit of flexibility in that procedure or handbook provision to help with those, unlikely or unknown situations. And so, yes, 48 hours is the absolute minimum. It's important to, when that meeting is posted with that minimum amount of time, that the agenda isn't adjusted. We sometimes see situations where a meeting is posted and then there's an agenda item that says additions to the agenda. The first agenda item is additions to the agenda, or changes to the agenda, or approval of the agenda. We just had the public get 48 hours notice to a meeting, or 7 days notice of a meeting. And then your first thing you're going to do is change that agenda that the public has relied upon. I encourage boards to rethink that type of agenda item so that you always operate transparently. Things don't just suddenly emerge and appear on the agenda. that the public didn't know about, it'd be very easy for a member of the public to say, well, I looked at the agenda, there was nothing on it that I had any interest in, but then I heard that you actually took action on this issue that you added on your agenda for additions to the agenda. You could see how that would really deteriorate into a finding against the library. So once your agenda is posted and that 48 hours starts, it's best to leave the agenda alone and not add to it to avoid the risk of someone claiming that their rights were violated because they didn't know what was going to be discussed.
That's really, all of this is really critical information. We're running towards the end of our time. I did put an evaluation link in the chat. We appreciate when folks take the time to give us your thoughts. And I share that information with Kris as well to help him with his work. And as always, we'll have our recording posted later this afternoon. And with that, Kris, you want to just wrap things up?
Yeah, the open meeting law is one that public records laws are one that I think you all as library leaders take seriously. As I said, as the managers and keepers of information, we want people to have access to it, and that includes our own information and how we operate and how we handle the public's resources for their benefit. And so utilizing those laws as a community engagement tool is important. The open meeting law isn't something to circumvent or be viewed as an obstacle or somehow burden. It should be embraced in order to demonstrate at all times that we take our role as stewards of information and resources, money seriously, and we are going to do whatever we can as those keepers of information to make it available to the public. And that includes our meetings, our committee meetings, and our documents and our budgets. So I have a passion for it because it's so critical to our communities and to the strength of our state. So I encourage you to take it seriously as well. View it as a community engagement tool that it is. And if you have any questions about how to maximize it, let me know, whether it be public records, public comment, public meetings, public notice, and public engagement. I'm ready to help. And I hope to hear from you soon and see you all at a meeting sometime down the road.